So a case challenging the NFA and its restrictions on SBRs is now in front of the Supreme Court and is heading to a conference. This case asks for the Supreme Court to find that the NFA and its SBR restrictions are in fact a violation of the Second Amendment. However, the Trump administration responded to this case, and they responded in a very interesting way. So let's talk about what is happening. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply subscribe to the channel, like the video, and also drop a positive comment down below, because that tells the algorithm that you appreciate this type of 2A content and it should share it to more people. As I mentioned in the intro, in this video, we're going to be talking about a very important case that is now in front of the Supreme Court and is seeking review. This case is a challenge to the NFA and its SBR restrictions. This challenge asks for the Supreme Court to find that those restrictions in the NFA are unconstitutional under the Second Amendment. The petition also focuses on how the Supreme Court needs to finally step in to correct a lot of lower court defiance and confusion that's been going on when it comes to what are protected arms under the Second Amendment. Now, coming off the heels of the Supreme Court's recent denial of rifle and magazine ban challenges, this case might actually have a long shot, but the NRA is trying to get the Supreme Court to finally address this issue as it applies to SBRs. Now, interestingly, the Trump administration just sent a notice to the Supreme Court waiving their response to the petition, and they will only respond if the Supreme Court actually asks them to file that response. Now, in response to that, the Supreme Court's docket now indicates that the case has been set for conference on September 29th. This could mean a couple things, but as of right now, this has been set for conference in September, and the US government has waived the response. Now, if you're not aware, in this case, Mr. Rush was charged with possessing an unregistered SBR. It was an AR-15 that had a 7.5-inch barrel, I believe, and he was charged with violating the NFA. Now, Mr. Rush argues that his conviction should be essentially wiped out because the NFA and its registration requirements, taxation requirement, and all the things that are involved in the NFA in fact violate the Second Amendment. Now, in this case, at the lower court level in the district court, Mr. Rush moved to dismiss the indictment, arguing that the NFA's registration requirement does violate the Second Amendment. The court denied that motion, concluding that the short-barreled rifles in question are dangerous and unusual firearms and therefore are not protected under the Second Amendment. Mr. Rush, in response to that, entered a conditional guilty plea, preserved his right to appeal, and then ultimately appealed up to the Seventh Circuit. The Seventh Circuit, on review of this case, affirmed the district court's decision, relying on the Supreme Court's recent ruling in U.S. versus Miller, which was a 1939 case, which is one of the landmark cases when it comes to the Second Amendment, and they upheld the restrictions on SBRs because of Miller. The Seventh Circuit found that Miller remains controlling on this issue and that the NFA's restrictions are consistent with the historical firearms regulations, as also mentioned in Bruin. Mr. Rush has now filed his petition to the Supreme Court, asking for them to reverse those lower court decisions, and he wants them to find that the NFA and its SBR restrictions do in fact violate the Second Amendment. Now, the question presented in this petition to the Supreme Court to address is whether the Second Amendment secures the right to possess unregistered short-barreled rifles that are in common use for lawful purposes. In the petition, the NRA argues that since the Supreme Court issued Bruin, courts across the country have struggled to answer the many questions resulting from the court's new analytical framework. In particular, the debate as to what constitutes a bearable arm covered by the Second Amendment has revitalized relevance. This case presents several issues that are dividing lower courts and is a suitable vehicle for the courts to clarify what arms the Second Amendment protects. So one of the interesting things to note with this case is even though it deals directly with SBRs and the NFA and all those arbitrary restrictions under the NFA, this challenge also addresses a larger question about what type of arms are protected under the Second Amendment. This impacts other issues like state rifle bans and magazine bans because it deals with that larger question about what are protected arms. In this petition, the NRA states that the Seventh Circuit has manufactured its own test, which seemingly cannot be satisfied. In this case, the court paradoxically dismissed short-barreled rifles' popularity and proliferation as having little jurisprudential value, while simultaneously concluding that Rush failed to prove that they are commonly used for lawful purposes. Although the court claims that its test is basically compatible with Bruin, Bruin's author, joined by Heller's author, condemned it for flouting our Second Amendment precedents. The petition asserts that short-barreled rifles are in common use, citing statistics showing that there's at least 532,000 registered SBRs in the United States. The NRA also criticizes the Seventh Circuit for dismissing evidence of their widespread lawful ownership. They also argue that the NFA's registration and taxation requirements lack historical support. They argue that the historical regulations cited by the government and also used in the lower courts, such as colonial era militia laws and taxation statutes, are not relevantly similar to the modern NFA and therefore do not justify how the NFA currently operates. In the end of the petition, they asked for the Supreme Court to grant cert to resolve this issue and provide guidance on the scope of the Second Amendment's protections when it comes to SBRs and other types of arms. And essentially, that's what I mentioned, it being a broader question. Although it deals with SBRs, it still is addressing a broader question about what are protected arms. Now, like I mentioned, in reaction to this, the U.S. government, through the Solicitor General John Sauer, just gave notice to the Supreme Court that they are waiving their right to respond to the petition. The notice that they submitted to the Supreme Court states that the government hereby waives its right to file a response to the petition in this case, unless requested to do so by the court. Now, in general, a party waiving a right to respond in the Supreme Court is not something that's super rare. It happens quite often. And often it could happen if a party does not intend to file a brief in opposition. And often that could also indicate that the party there believes that the petition is clearly without merit and doesn't require their response at that time. Sometimes this is also used as a procedural mechanism where the party can avoid filing a brief initially until actually forced to do so by the Supreme Court. If the court is not interested in the case, well then maybe they'll just move along with the case and the party there will actually never have to respond. Now, recently we've seen the federal government, the Trump administration, take a position change in a lot of cases, especially NFA cases like suppressors. The Peterson case out of the Fifth Circuit, they filed briefs saying that yes, suppressors are protected arms, that they deal with protected arms, but they still argue that the NFA's restrictions and process do not amount to a complete ban and therefore is still constitutional. I would expect if the federal government is required to respond to this case by the Supreme Court, they would kind of argue along the same lines, arguing that SBRs potentially are protected arms and that maybe the lower courts got that wrong, but that the NFA's process and restrictions are still constitutional and should still stand. The Trump administration may not want to have to file those types of arguments right now to the Supreme Court, so maybe they're just simply waiting to the Supreme Court to actually, requires them to do so. And this could kind of be just a strategic play where you either get the court to consider this without actually having to make those arguments, or just push off having to make those pro-SBR arguments right now in a brief, especially with a lot of other things going on. Now, after that notice was filed to the Supreme Court that the Trump administration was waiving their right to respond, the Supreme Court's docket actually indicates that this case has been set for conference on September 29th. Now, just because it's set for conference does not mean that the court will not request a response from the Trump administration actually before that conference, or there's even the possibility that after that conference date, we would get a notice on the docket saying that, yes, we want the U.S. government to respond and file a response brief to this issue. This could also be a situation where maybe they're using that future conference and the waiver of the response right now as a placeholder to essentially see what happens with the SHORT Act, which is currently moving in the Senate and is, right now in an active effort to get that passed through the Big Beautiful Bill. Of course, if the SHORT Act is passed in the Big Beautiful Bill, that would pretty much moot a lot of these cases and a lot of these issues. So maybe the September conference that's set right now and the waiver of response are just being used as a placeholder to see how the SHORT Act plays out. So we're going to see how this develops. It's also going to be interesting to see how the Trump administration responds to the petition if the Supreme Court asks them to file a response. Again, I suspect that they're going to do something similar to what they did with the Fifth Circuit Peterson case. They're going to argue that the NFA and the SBR restrictions are constitutional because they do not amount to a complete ban, but maybe they're going to say, yes, these are protected arms, that the Supreme Court needs to review this, or that the lower court needs to reevaluate this and realign in light of the new position that SBRs are protected arms. So again, very interesting developments in this case with the waiver of the response and now it being set for conference in September. Right now, we haven't seen an indication from the Supreme Court that they want the federal government to file a response in this case. So that could maybe be telling if the Supreme Court just wants to punt this, further in the next term, or just kick it after they review it in the next term at conference. So we're going to see how this develops. And I think the big thing that's really going to impact this and how this case develops going forward is whether or not the SHORT Act is actually passed in the Big Beautiful Bill. But of course, as we get more information on all of that, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.